Thank you very much for joining us today for what is the first in a series of webinars focused on content specialized for the insurance industry. I'm Laurie LaPalme, and I'm the national lead of Denton's for the Corporate Insurance Regulatory Group. As you may be aware, Denton's Insurance Group is one of the largest and most comprehensive group of legal practitioners, having expertise in regulatory compliance, M&A, commercial agreements, as well as insurance defense, litigation, and coverage matters. Denton's Canada is also a national firm comprising of 6 offices and 500 lawyers. We are a full service firm experienced in 24 sectors and 40 practice areas. And today we wanted to introduce you to our insurance clients, our labor and practice group. Our labor and practice group is very much experienced in employment contracts, restricted covenants, confidentiality agreements, and pretty much any sort of employment policy or labor-related concerns. We can provide advice that on anything that touches your workplace, including workplace health and safety, harassment policies, privacy, wellness, and today we are going to be talking about COVID and return to work. So I'd like to introduce you to my partner, Meaghen Russell. Meaghen represents numerous employers across Canada, and she specializes in all aspects of employment and labor litigation, including wrongful dismissal matters, grievance situations, restricted covenants disputes. Meaghen's presentation today will cover the top 5 return to work considerations that employers need to be aware of and how to expect and work with the problems that surround returning to work after having 15 or 16 months now off on a stay-at-home mandate. After the first half an hour or so, we'll then enter into a more informal question and answer period. So please post your questions in the Q&A and we'll try to get to them. So we all know and we have all heard about, that Ontario is slowly opening up, which we're all excited about, and we're all going to get back to business. But that leads to a lot of considerations that employers need to be aware of. And on that note, I'll turn it over to Meaghen to discuss at least the top 5 considerations to be aware of. Meaghen.
Great, thanks, Laurie, for that introduction, and welcome everybody this afternoon. While Laurie mentioned that this webinar is geared towards the insurance industry, my comments regarding the return to work considerations and issues certainly apply across industry and sectors. So just in terms of a brief agenda, by way of introduction, I am going to talk a little bit about how close we are to a return to work. And by that, I mean to the physical office or workplace. And then in terms of the top 5 considerations, I'm going to cover mandatory vaccination policies, masking refusals, employee refusals to return to the office when you try and get your folks back from remote working, considerations for reopening your physical workplaces. So what does that need to look like? We'll talk about the COVID plan, if you will, in regards to the return to work. And then at the very end, I'm just going to provide a very high level, quick refresher on COVID-19 paid sick time or sick leave across the provinces. If you do have questions about the COVID-19 paid sick days or hours across the province, if you have more detailed questions than what we cover today, our colleagues have certainly been providing blogs, articles, and there was a webinar last Friday that really dove into this topic. So I would encourage you to look for those materials and reach out if you can't find them, if you'd like a copy of them. All right, so turning to the introduction here. So for those outside of Ontario, my apologies, this will be specific to Ontario, just a quick primer. So as most of you know, we have been in a state of emergency break lockdown, subject to a stay-at-home order until yesterday. So by way of recap, the stay-at-home order essentially meant unless you were going to the grocery store, the pharmacy, seeking medical, going for a walk, or otherwise exercising, or traveling to work at an essential business or service. Otherwise, you really weren't supposed to be leaving your house. So that is no longer the case. The state of emergency in Ontario also ended yesterday. And we know from the Premier's office that they are focused on reopening the province by way of this 3-phased approach. So the first phase is supposed to start on June 14th. It could start earlier, it could start later. It really depends on whether or not we're meeting the vaccination threshold to get us to phase 1. What that means is the province needs to see that at least 60% of adults have received at least the first dose of the vaccine. So that's the trigger date to phase 1. So you may be asking, okay, we're out of the stay-at-home order, we're out of our state of emergency in terms of that declaration. What's the state between now and whenever phase 1 starts? So there is legislation called the Reopening Ontario Act. That act and the regulations, with the exception of the stay-at-home provisions, are going to remain in place until at least June 19th. What does that mean for business? That means that currently employers are still required to comply with public health guidelines, and the current guidelines and recommendations continue to be that employees should be working remotely wherever possible. So that's just something to keep in mind. Yes, we're out of the stay at home, but it's not like employees can start, returning to the physical offices in droves. Really my advice leading up to phase 1 and as we go through phase 2 and phase 3 throughout the summer is to really pay attention to the advice from the provincial government, from the local public health authority, so that we have a full understanding around our parameters and when we can start bringing people back in greater quantities. My apologies, it got very dark in here for some reason. Okay, so if we turn to the next slide. Thank you. So the next topic, the first return to work consideration that I want to flag for you is with respect to mandatory vaccination policies and whether an employer can implement these. So 3 questions, right? Can we make vaccines mandatory for our employees? Can we track employee status? So vaccinated versus non-vaccinated. If we can't incorporate a mandatory policy for reasons I will get into, can we ask employees to volunteer the information about whether they have been vaccinated? So the starting point here for this consideration is really to understand that there is no current legislation federally or provincially that mandates vaccines. So that's an important starting point. I have flagged here on my slide the Ontario Ministry of Health direction from this past Monday. So you may have heard that on Monday, the Ontario government issued a directive to long-term care homes that they have to establish, implement, and report on COVID-19 immunization policies, and they have to do this by July 1st. What is interesting and important, I think, about this development is the fact that there has been this directive that a policy has to be created, but what the government didn't do and where they fell short is they didn't mandate vaccines for workers who work at these long-term care homes with these vulnerable populations. What they have to do is, and what they have to report by July 1st, is to ensure that each staff member, volunteer, or student placement do one of the following. First, provide proof of vaccination of each dose as they get their doses. Second, provide a documented medical reason from a doctor or nurse that sets out the reason why they can't get vaccinated and the time period for which they can't get vaccinated, if the reason is sort of time sensitive, for example, a pregnancy. Or, and this is interesting, participate in an educational program that reviews the benefits of vaccination and the risks if you decide not to get vaccinated. So why am I talking about the Ministry of Health directives with respect to long-term care homes on a seminar specific to the insurance industry. I'm flagging this for you because I think this is telling. The government has not mandated vaccines in hospitals, and they haven't come out and mandated vaccines in long-term care homes. There might end up being reasons why certain employers in the healthcare sector may decide to institute a mandatory vaccination policy based on the balancing of interests between health and safety and privacy. But what I'm essentially saying is, if the government is not going to mandate vaccinations in those sectors, I don't think they're going to be opening it up and mandating in other non-health related sectors for some time, if not forever. And I think that in and of itself is going to, essentially foreshadow the uphill battle it's going to be for a lot of employers to try to justify mandatory vaccination policies. Obviously, these types of policies are untested in Canadian law when it comes to COVID. The other thing you're going to have to consider if you're thinking about whether to implement a mandatory vaccination policy is the issue of the vaccination supply itself. In terms of getting into phase 1 in Ontario, at least, they're hoping to have 60% of adults having received at least the first shot. I think that is telling, right? That, there's no expectation yet in terms of timing for when adults are going to be receiving the second shot. The data certainly doesn't suggest that that is going to be completed by the end of the summer. So if you are going to look at this kind of mandatory vaccination policy, and if that timing aligns with the government essentially allowing, a large number of employees to return from remote working, we're going to have to consider the fact that a lot of folks may not have had the ability to be vaccinated yet. Next slide, please. Okay, so the next thing that I want to cover here is this issue around whether or not, what your considerations should be, at least from a legal perspective, in terms of whether to implement a mandatory vaccination policy. So the starting point is going to be, is there a serious risk of health and safety risk in the workplace? So what's happening in your workplace? Are you dealing with COVID outbreaks? Is there an elevated risk of a COVID outbreak for a particular reason that may justify the implementation of a mandatory vaccination policy? I would note here that if you did implement a policy and it was challenged, we would have to show evidence of infection in the workplace in order to justify why it's required. The other consideration is whether there's evidence that vaccinations will minimize health and safety risks in the workplace. I think it's probably early days on that, given the fact that the effects of the vaccine are still being studied. But again, if you move forward with a mandatory policy and it was challenged, you would have to provide evidence that vaccinations do reduce the risk of infection of COVID in the workplace. The next consideration, and I think this is probably the most important, whether there are less intrusive methods that can be adopted to minimize any health and safety risks in your workplace. So in looking at that or reviewing that type of question, are your current COVID-19 protocols sufficient and or effective? So we're talking about your masking policies, your physical distancing requirements, your screening, your cleaning, your sanitization, all of those things that have gone into your COVID-19 return to work safety plan, if you have developed that yet, all of that needs to be considered. If you're taking the position that your current health and safety measures are not adequate to properly protect your workforce, and that's why vaccines are becoming, or need to become mandatory, I do think that there is a little bit of a challenge there, because you're going to have to rationalize why the vaccine is now necessary when your previous safety measures were fine and kept everybody healthy and safe in the workplace. So you'd have to think about how to rationalize that. If your policy did end up getting challenged, you would need evidence from medical professionals and health and safety professionals to establish why your current safety protocols were not sufficient. The next consideration is, does the seriousness of the risk and introduction of a vaccination policy outweigh the harm to employee privacy? So in that, you would have to look at the characteristics of your workplace. Again, are your current health and safety protocols sufficient? Are they reducing, the case of infection related to the workplace? Obviously, in the healthcare sector, I think when we're looking at this balance between health and safety and, again, rights to employee privacy, in the healthcare sector, because folks are dealing with a vulnerable population, I think the balance is more so in favor of health and safety. You probably also heard in the news over the last year, there had been a number of massive COVID outbreaks at meat processing plants. And the issue there is, yes, they were trying to do everything they could to follow proper health and safety protocols, but the way that their production was set up was such that folks could not keep 2 meters apart from each other. So the physical distancing was not essentially manageable because of the layout that could not be changed in those circumstances. So in that case, there's an example of the current health and safety protocols. They're doing everything they can to abide by them. They're still not sufficient enough to prevent these massive COVID outbreaks. The other thing to note, again, if you're considering mandatory vaccination policies, is whether there will be discrimination risks. So if you have a blanket policy that essentially says, you can't return to the office until you prove to us that you have been vaccinated, that in and of itself may be discriminatory if any part of your population is not able to get vaccinated and refuse to get vaccinated due to some protected human rights ground. So as I mentioned before, perhaps there's a, pregnancy and somebody has been advised by their medical provider not to get the vaccine. Perhaps the refusal is on the basis of creed or religion or some other form of disability. Those are factors that you're going to have to think about. And if you are going to move forward with a mandatory policy, we would absolutely recommend that there is a carve out, if you will, that reflects the duty to accommodate that employers have. One thing I want to mention here, and this is different than what our US counterparts are hearing from the CDC, is that the National Advisory Committee on Immunization Records, or NACI, they are still recommending that employees, folks, continue to wear masks, even though they have been vaccinated. So when you're thinking about whether, it absolutely needs to be a requirement for somebody to be vaccinated in the office, I'd encourage you to, think about this situation in the context of the fact that both the vaccinated people and the non-vaccinated people, whether we know who they are or not, they're all still going to have to follow the same health and safety protocols. They'll all still have to wear their masks, subject to some exceptions, which we'll talk about. They're all going to have to, remain 2 meters apart in terms of the physical distancing. You're still going to have your cleaning protocols and your signage, et cetera. So, when we look at, do you reasonably, need somebody to report on their vaccination status? And are you in a reasonable position to prevent somebody from coming to the office because they haven't been vaccinated? Is that going to be seen as reasonable by an adjudicator, court, judge, arbitrator, whomever, given the fact that everybody still has to continue with these same health and safety protocols that, essentially have been in place and for the most part working for, up to 15 months while we sort through COVID. One note on vaccination incentives. Obviously, most provinces have provided some form of paid COVID leave, whether it be a couple hours or up to a couple days, in order to, in part, get the vaccine. So that's been great. That's obviously a big incentive for people to go and get their doses, given that if they have to go during working hours, they will be compensated. If you decide to have a voluntary vaccination policy, so people can consent to this disclosure, can offer up this information to you, we would suggest that you be careful if you're considering providing incentives. So if you were to say, anybody who can prove that they got their shots are going to be entitled to a vaccine bonus, you have to be mindful of the fact that some people may not be able to get the vaccine due to protected grounds under the Human Rights Code. And if you treat these people differently, that is going to be the basis of a human rights claim. All right, next slide, please. All right, so the next question I want to cover is, can you ask for proof of immunization or vaccination? So can you ask employees if they have received the vaccine? The short answer is yes, you can ask. However, the employees are not legally obligated to answer that question. So just something to keep in mind there. If you do ask and they do offer the information, or if they voluntarily offer up to you, hey, I got vaccinated last Friday or what have you, then what kind of proof should you be looking for or asking for? Because one's vaccination status is considered personal medical information, we would encourage you to exercise caution in terms of requesting too much information. So I think it's reasonable to ask for, either a verbal commitment or a verbal representation that somebody has received the dose, or to have the person, show you their vaccine record, certificate, email from the Ministry of Health, whatever you have. We don't recommend taking a copy of the record, given that that is in fact a medical record. The other thing I'd like to note, and this is specific to the Ontario Occupational Health and Safety Act, is that there is a provision that employers do not have an express right or power to require such information. In fact, the Act provides that an employer cannot seek to gain access to a health record concerning a worker without the worker's written consent. So again, this goes to, is it reasonably necessary for us to ask this question? If we're having folks voluntarily provide this information, then don't ask for a copy of the medical certificate. I think we can document that in a different way. The other thing I would flag here is, because this is a disclosure from a privacy perspective, we want to make sure that the purpose of collecting the information is limited and the purpose is communicated to the person. So if you are going to track this status on a voluntary basis, I would encourage you to put essentially your policy on this in writing so people understand what is the intention, what is the limited purpose, the fact that we are going to get individuals' consent to get this information, a commitment that disclosure will be limited, that the information will be held securely, given that this is personal medical information, and that the information will be subject to destruction as soon as it's reasonable and the information is no longer required. All right, next slide, please. Okay, turning to masks refusals. So can employees be required to wear a mask or face covering? I'll refer to those as masks for the duration of the presentation. Can employees require masks at work? The good thing is most provincial governments are providing guidance on this, or the public health authorities are providing guidance. And if the government is telling us we have to do it, subject to some exceptions, then really it's outside of the employer's control and we need to do what the governments are telling us. I want to flag for you, again, this is specific to Ontario, but I've seen comparable legislation in other provinces. There is a section in the Reopening Ontario Act that states, the person responsible for a business or organization that is open shall ensure that any person in an indoor area of the premise of the business or organization wear a mask in a manner that covers their mouth, nose, and chin during any period when they are in the indoor area, unless, and there are a number of exceptions, I'm not going to read them all, but I'm going to read you the key ones. So unless the person has a medical condition that inhibits their ability to wear a mask, they're unable to put on or remove a mask without the assistance of another, they're being accommodated in accordance with the Accessibilities for Ontarians with Disabilities Act. They're being reasonably accommodated pursuant to the Ontario Human Rights Code, or, and this is interesting and important that everybody knows this, or they perform work for the business in an area that is not accessible to members of the public and where they're able to maintain a physical distance of at least 2 meters from every person while in the indoor area. So what does that mean? It means if you have staff that will not have interaction with the public, will not be in areas accessible by the public, and they can keep a 2-meter distance from their, colleagues, coworkers, passersby, then they do not have to wear a mask under this regulation. This is the current regulation. We could see that specific provision change. It's hard to say when Ontario starts to further reopen with respect to workplaces. So, if we're at a point where we're up to, 50% capacity or higher, whatever that number is going to be, perhaps the Ontario government is going to have to take a look at that exception to say, is that necessary? Because if we have people coming back in droves, there could be a case where people are going to be within 2 meters apart from each other. So all that to say, the order to wear masks provincially is subject to the duty to accommodate. We'll talk a little bit about this just in this case that I'm going to highlight, but essentially, the core of this is going to be, in terms of mask refusals, sort of health and safety issue versus what we see as a rights issue. So people asserting it's their right not to wear a mask. They can make that decision, or they don't support the science. That's not going to be a legally protected ground to refuse to wear a mask. Next slide, please. Okay, so a couple comments about a case called Sharma versus the City of Toronto, which is a 2020 Human Rights Tribunal decision. In this case, the City of Toronto issued a bylaw requiring businesses to adopt a policy to ensure that no member of the public be permitted entry to or be permitted to remain within any enclosed space unless they're wearing a mask or face covering. The bylaw did, however, reflect that there is a duty to accommodate and that the policy would not apply where the person who was seeking to enter the premises had an underlying medical condition that prevented the mask wearing, or persons who are being reasonably accommodated by not wearing a mask in accordance with the Human Rights Code. So the applicant tried to attend a number of businesses without wearing a mask or face shield and was not permitted to enter. The applicant then sued the City of Toronto, alleging that the bylaw was discriminatory on the basis of the applicant's creed and disability. Of note, the applicant did not sue the individual businesses that had denied access. They instead sued the city due to the publishing of the bylaw. With respect to creed, the applicant stated to the tribunal, quote, "My creed disagrees with covering my face for unsubstantiated claims. Claims that masks prevent or stop the spread of COVID-19 is not substantiated by scientific evidence. My creed requires that I do not blindly accept wearing a mask. I do not blindly accept what government or agencies claim, mandate, or enact into laws." So essentially, the applicant asserted that his creed prevented him from wearing a mask because, according to him, there was no proof that masks limit the spread of COVID-19. In terms of the HRTO's decision, the matter was dismissed. They found that the bylaws were not discriminatory, given that they included the duty to mitigate. And importantly, with respect to this whole notion of discrimination on the basis of creed, the HRTO found that the claim was based on his mere political opinions and not on a sincerely held religious belief. So why am I telling you about a case involving a patron trying to access or attend a business? I'm flagging this because you could find yourself in a situation where you're trying to move people back into the office from remote working, where folks are going to say that they can't wear a mask or a face shield because of some legally protected grounds. Those grounds would include, them having a disability, them having a sincerely held religious belief that prevents the wearing. I've shared this case with you because it really stands for the proposition that, a belief that mask wearing is not appropriate, or a preference to not wear masks, or somebody asserting that they have a human rights or a charter right to not wear a mask is not going to be sufficient. And I would encourage you, if you do find yourself in this situation particular to creed, I mean, you can ask for a statement of religious belief to try to verify whether this is actually a sincerely held religious belief as opposed to a preference. Okay, next slide, please. Okay, so we've been getting a lot of questions about returning to the workplace and what to do if there are employee refusals, and also what rights do employees have to insist on continued remote working if that's what they want to do. So the first thing I would suggest, if you haven't thought about this already, a lot of clients is what will your return to work look like? Is it going to be a hybrid approach with, partial remote working, partial work in the office? Are you going to shut down your brick and mortar office and everybody will work remotely? Or the, converse to that is, will everybody be required to return to the office with, no or limited access to remote working? So, if and when you're at the point where you're going to be asking people to come back into the workplace, you're going to get a variety of reasons why folks are going to say they can't come back. If somebody says it's their preference to work from home, they feel like they're more efficient at home, they like the commute, they like their lunchtime colleague, whatever it is, those are not legal grounds to refuse to come back into the office. If somebody says, hey, FYI, I moved 4 hours away without telling anybody, so now I live too far away and I can't reasonably commute, you have to let me work remotely. No, you don't. The only caveat to that is if the person asked you whether they could move that far away and whether they'd ever be asked to return to the office and you said, no, don't worry about it, that's going to be a different scenario. But them having made a personal decision to move essentially out of range, that is not a protected legal ground in which to request accommodation. What we're going to see are these accommodation requests in the context of, most likely, childcare obligations, perhaps elder care obligations. Your duty to accommodate there is going to be no different than in the pre-COVID context or world about whether or not remote working is a suitable accommodation for somebody who requires, say, family status accommodation. Somebody saying they are fearful of COVID-19 is not a basis for them to refuse to work. Actually, if we could move up a slide. Thank you. So I'm just going to flag this high level. If you do end up dealing with a work refusal situation, there is a sort of formal process under the Occupational Health and Safety Act for work refusals. Generally speaking, the person has to explain why they feel the workplace is unsafe. The employer investigates and reports the findings back. Either we agree or we disagree, depending on what the issue is. And oftentimes the Ministry of Labor ends up coming out and assessing the unsafe condition to determine whether or not the employee does have a right to refuse that unsafe work. I can tell you that in the last 15 months, the Ministry of Labor has attended multiple work sites because people have claimed that they're scared to come back because of COVID. When the Ministry of Labor knocks on the door to do this, I'll call it inspection, I mean, if the employer is following their health and safety protocols, then there's no basis in which somebody's going to be able to refuse to work because they're fearful of COVID. The same is going to go if you have vaccinated folks who are finding out that other people don't intend to be vaccinated. That is not a basis in which the vaccinated folks are going to say, well, we don't want to go to the office if we're going to be exposed to non-vaccinated people. Next slide, please. Okay, I talked about this a little. I'm not going to dig too much into this slide, only to suggest that a lot of you probably have employees who are on infectious disease emergency leave, or IDEL. That type of leave isn't going to last forever, as it is specific to COVID, and hopefully COVID will end at some point in time. But just to be mindful when you're dealing with remote working requests, who you have on IDEL and for what reason. Okay, next slide, please. All right, I'm not going to read these to you. You're going to have them here for your reference, but basically some practical tips when, looking at returning to the workplace and employee refusals. Next slide, please. Okay, so the fourth thing I want to talk about are your reopening considerations vis-a-vis the physical workspace or office. So a year ago around this time, we were talking to employers about, reopening the workplace and what that's going to look like and what your plans need to include, because we all thought we were going back to work last summer or fall. Fast forward a year later, the government's current guidance on reopening considerations has remained the same. I have given you the link there in the case that you want to take a look. I've also given you the factors, the 9 or so factors that the government has included in terms of what you should at least currently be thinking about around a reopening. This guidance will change over time. You'll see here the first post or the first bullet point is workers should work from home if possible. At some point, of course, Ford's going to reopen, businesses when we're at that point. I do think the government will continue to be cautious and conservative, but at some point we will be reopened and people will be coming back in. So I'm flagging this for you because as you're starting to think about a reopening, if you haven't, last year at this time, if you didn't put together a COVID-19 return to work plan because your office hasn't effectively been open since last March, then now would be a good time to start turning your mind to these considerations. Again, I'm not going to read them, but I'd encourage you to do that when you start looking at your plans. Next slide, please. Okay, this is a continuation of those considerations. The only thing I want to highlight on this slide is, again, to consider, do you have a COVID-19 workplace plan or protocol in place? If you don't, Dentons has created a COVID-19 employer return to work checklist. It's quite involved. We tried to cover off as many considerations as we could possibly imagine to give you a guide in terms of the things that you're going to need to think about in terms of safeguarding your workplaces when you start to have employees ramp up their returns to work. Next slide, please. Along the same line, again, I'm not going to read these, but a lot of questions for you to consider. Many of these are included in our return to work checklist. So if you do want a copy of that, feel free to reach out to Laurie or I, and we can make sure that you have that. And then finally, next slide, please. As I said, just a quick note on COVID-19 paid sick leave. I've given you the entitlements on this slide just as a quick reference point. I'm not going to read them all to you, but I figured it's important for you to have, whether you're dealing with these requests while people are remote working or while people are back into your physical office spaces, you're going to need to know what these entitlements include. If you do provide any measure of paid sick time off already, depending on which province you're in, you're going to want to be mindful of that in some provinces, you can utilize the, current paid time in your policy as against these entitlements. In other provinces, you can't. So I'd encourage you to be familiar with the legislation in each province just to make sure that you're getting it right. And next slide, please. So I think we've got some questions.
But yes, Meaghen, we've received some really good questions, and why don't we start with one of them, and it involves refusal. What happens if you have an employee that's at work, the government has not mandated a vaccine policy, the employee is refusing to wear a mask? What can an employer do?
So in that context, so they're saying they won't get vaccinated. So fine, there's nothing legally requiring them to get vaccinated, whether it's due to an accommodated ground or not. They're also refusing to wear a mask. So specific to Ontario, to that exemption that I talked about that's currently in place, is this somebody who, is working at the office in a position where they don't have access to the public, and they're in their particular workspace or work site, there is no public access? If the answer to that is yes, and the individual or the employer can ensure that the individual maintains at least 2 meters distance apart from other people in the office, then there really isn't going to be a basis to deny that. If you conversely find, this is somebody who is going to be in contact with a member of the public, or their workspace will be accessible by a member of the public. If that's the case, then you're not going to be able to accommodate them by continuing to have them in the office without wearing a mask.
So another question that we've received that was really helpful, Meaghen, is we understand that employers can ask employees voluntarily to disclose whether or not they've received the vaccine. But what happens in the interview process? Can you ask potential candidates?
So that's a really good question. I'm going to say this isn't an answer across all provinces. In some provinces, you can, when you're considering new hires, you can make it a condition of employment for somebody to be vaccinated. If you're trying to impose a condition during the employment, then that's when we see the potential constructive issue, constructive dismissal claims, where somebody's going to say, hey, wait a second, you're unilaterally imposing a new term of employment, which is I have to be vaccinated. That's constructive dismissal. However, there's nothing preventing you on the front end. Again, you'd want to check on depending on which province you're in, but in the provinces that are permitting this, you can put into an offer the normal, this offer is conditional upon language, reference checks, background checks, proof of vaccination. If you're going to do that, we're going to want to, as I said, have that policy in place that we can give to folks about how we're going to preserve their privacy and the limited purpose and what we're going to do with it, et cetera.
So we're getting a lot of questions about refusal to work or mandating the return to work. I know you touched on this, but maybe we can clarify it a little bit. Can an employer mandate 100% return to work? Can an employer say, no, we're staying 100% home? And can an employee refuse to work part from home, part for work, or have a say in their work arrangement?
Sure. So I have a number of clients that have determined throughout this pandemic that they don't need a brick and mortar office and they're going to go to 100% remote working. If that's the decision, that's entirely fine. Conversely, if an employer decides that they're going to have everybody return to the office, subject to the duty to accommodate that I talked about in terms of childcare, elder care, perhaps medical grounds for accommodation, then yes, you can have everybody return to the office subject to that duty when the government essentially tells us that we're able to do that. Where it gets a little bit tricky is if you're going to have, a lot of folks returning to the office and you're going to tell certain folks, we don't want you to return to the office, we want you to stay at home, there could be a constructive dismissal issue that may arise because of the fact, yes, you're not changing their compensation or their role or their duties, but there could be a difference in terms of what the opportunities are that this person is going to miss because they're at home and they're not in the office and getting that face-to-face time with their superiors. So that is something to think about in terms of a potential claim if you're going to try and say these people are in the office, these people are out of the office. If you have entire departments, so finance is going to be home, but HR is going to be in the office, I think you have less of a concern because it's not like, one is missing an opportunity that the other has if the entire department is in one place together.
So insurance is very sales oriented, and it always has been traditionally, especially with brokers and MGAs. They're out meeting with clients, and it's traditionally been meeting at the client's location, the client's employer, or at a restaurant or a coffee house. What kind of protocols and procedures can an employer mandate on these client interactions?
Yep, so that's a good point. I mean, there is an obligation, and this is across Canada under occupational health and safety legislation, to take every reasonable precaution to protect, somebody's health and safety in the workplace. The workplace is going to extend to those meetings at a coffee house or in a restaurant or wherever they're going to be. If you have sales, meetings and you're expected to go to the client's site, as the employer, in an abundance of caution, I mean, perhaps you're going to ask those questions around like, what are the safety protocols that you guys are following, just so that we can make sure that, our people are aware, right? So are people wearing masks when they're sitting in boardrooms together? Or, are they going to be wearing masks if they're traveling in a, Uber together en route to, a function or a meal or what have you? I don't think it's unreasonable to ask those questions to make sure that there's an understanding about any potential health and safety risks on the part of your employee.
What type of, so an HR person would be asking information about vaccination or not vaccination. Who can that HR person then share this information to amongst employees? Can one employee ask another employee or a superior whether or not their fellow employee was vaccinated, or are there rules around privacy around that?
There absolutely are. No, whether it's HR or if a manager is aware, the quote unquote employer should not be communicating vaccination status to other people. As I mentioned, this is personal medical information. The best practices with respect to preserving and safeguarding confidential information and personal health information apply here, as it does with any other type of information. If employees want to, chat amongst themselves about, oh, I got my shot, oh, I'm scheduled, there's nothing to prevent that from happening. It's going to happen. It is happening. I can tell you, I've been on calls where other people have talked about it or where I've talked about it. That's separate and apart. If people want to talk to each other about it, employee to employee, there's nothing that we can do. But if an employee says, I've heard through the grapevine that so-and-so is an anti-vaxxer, I want confirmation if that person's been vaccinated, the employer absolutely should not be sharing that information with employees.
Okay, well, that's good to know.
I know it's a tough one because, people are concerned. Certain people have, different positions on COVID, just in terms of, whether the employer is doing an adequate job in terms of protecting health and safety with the current measures that are in place.
So we talked about disclosure, and if an employee voluntarily discloses officially that they've been vaccinated, can an employer treat them differently? Meaning that we will prioritize vaccinated people back to the office first versus non-vaccinated people?
I don't recommend doing that. Because, now we're taking away this notion around whether the disclosure is voluntary. Like if we're saying there's going to be differential treatment, are we now more so coercing people to tell us as opposed to making the disclosure voluntary? So that's the first issue. And then the second issue is this human rights piece where you're going to have people, maybe not every employer, but a lot of employers, are going to have people who, due to medical, religious, gender, right, in terms of pregnancy, who are not able to get the vaccination in any event. So those people are going to be treated differently if they're being, second tier priority to the vaccinated folks. So you want to be really careful about that.
And if somebody decides not to wear a mask and they say it's a medical reason, are we allowed to ask for a medical note?
So that's a really good question. The answer is going to depend on which province you are in. I believe in Manitoba, the legislation specifically says you can request that supporting medical. Currently in Ontario, under that regulation that I referenced under the Reopening Ontario Act, it explicitly states that you cannot ask for supporting medical. Between the 147 people on this webinar, I think that is crazy. I don't see how this should be treated any differently than if somebody comes to you as the employer to say, I need an accommodation, I need to work part-time hours, or I need to, have this or that modification. In that circumstance, you're able to ask for reasonable supporting medical information. However, in this circumstance, you're not. So how do you actually test whether there is a medical issue that precludes the person from, getting vaccinated or or wearing masks. As we continue, hopefully, to evolve as a province and the guidance and the legislation changes and gears towards the greater reopening of businesses, I am hopeful that we're going to see that section in the regulation in Ontario fall by the wayside so that employers can actually start testing this.
So we have a question here about, we've just gone through top 5 considerations. Is there one thing that employers should do now? The one thing that is practical that you would recommend that an employer does now in gearing up for back to work and considering clients back in the office?
Yes, if you have not put together your COVID-19 return to work safety plan and protocol, now is definitely the time to do it. It is mandated by legislation. It's not a choice of whether you do it or not. So not only are you going to have your policy and your protocol put together, but you need to provide training to your employees about what these protocols are going to be before they start coming into the office. So by way of an example, Denton's, we did ours a year ago because we thought we were all coming back in the summer. But I can't show you, but there's a sticker right where I'm sitting, a circle that says sit here. And on this long boardroom, there are stickers that are spaced apart so that people can't be sitting, within 2 meters of each other. There are posters everywhere in terms of your entrances and your exits, right? They're not all open so that traffic flow can be continued. There's posters to say, before you enter this door, do you have a cough? Do you have a fever? Do you have this? Do you have that? There's a lot that's going to go into this. Obviously, the larger your workforce is and the more space you have, the more considerations you'll probably have. But this isn't something that you're going to put together the night before people are returning. So if you did your plan a year ago when we all thought we were coming back, I would suggest that you revisit it. Is there anything that needs tweaking, revising? If you haven't done it yet, now's the time to start thinking about what the office space physically is going to look like vis-a-vis the guidance from the government. And as I said, we do have this return to work checklist that really talks about sort of the physicality of different types of offices and the things that you should be considering.
So I know we breezed over sick days and paid sick days, and we're referring people to the seminar that we already have posted. But there's one question that keeps popping up, and that's the confusion about the 3 sick days. If they already have paid sick days in the organization, are those 3 days inclusive of their existing sick days, or are they in addition?
So if you have a policy that provides for 3 paid sick days annually, and your folks haven't taken their 3 paid sick days, then you can apply those 3 paid sick days to the government's 3-day mandate. If somebody's used the 6 days or 3 days already up, then they get an additional 3 days? Yes. Yes, that's correct. Just on the paid sick days piece, if you have a policy or contract that provides for paid sick time and the employee has already used the, we'll say the company funded time, and now they're, using their government 3 paid sick days, that isn't part of a policy or your contract, you can apply, and this is specific to Ontario, you can apply for reimbursement through the WSIB for those days. More generally, if you don't provide for paid sick time and your folks need to take, up to 3 days within the specific period of time that these days are available, which right now in Ontario is up until September, I want to say 26th-ish. Then if you don't have already in your plans paid time off for sick time, then you absolutely can apply to the WSIB for reimbursement.
And I guess this will be our last question. If an employee is called back to the office and they refuse to work, they don't have valid reasons, you've gone through the work refusal, when can it be deemed an employee resignation?
So that's a good question. We would view that as job abandonment. Essentially, what's going to end up happening is as employers are moving to reopen and get people back from remote working, you're going to want to be able to, hopefully, you're going to be in a position to provide as much advance notice as you can. So, hey, Denton's effective September 1st, everybody's going to start coming back to the office. If somebody says right away, I don't want to, then we would send another letter to them, or I'd recommend you send another letter to them, essentially saying, you know, the employer has the right with respect to this term of employment. You are required to report to work on X date. And if you don't report to work on X date, we will deem this to be job abandonment. If they don't, fast forward to day one of the return, if they don't return, again, because our courts are so employee friendly, I would recommend that we issue another letter to say, here we are at day one, you're not here. You know, we're giving you until whatever it's going to be, 3 days till the end of the week to return, to confirm that you're not going to be returning to your employment. And if you don't respond or you just failed to show up, then we will consider your employment or your position, your employment to have been abandoned.
Well, I looked at the time and we're down to 1 minute left. So I just wanted to thank everybody for participating. I think it's been a really informative session. I know we crammed a lot of information in a very short period of time, and this is a topic that's spurring many questions. So if we are keeping a copy of the questions, we'll try to get to them. Our next insurance webinar will take place on Tuesday, June 29th, and we'll be covering COVID business interruption claims. And it's basically an update on that. And then next month on July 27th, our third webinar in the series will be about risk management, how to protect yourself in the event that REBO or another regulator comes knocking in for an investigation. So look out for those invitations in the coming weeks. But thank you again, Meaghen, for sharing your time and expertise with the group. And thank you everybody for participating.